Hello friends. Today I'm going to speak to you about Article 13 of the Indian Constitution. This is one of the most important aspects of Part 3 of the Constitution because this is the particular provision which makes fundamental rights justiciable. This provides teeth to the law, so to speak, because it is only because of Article 13 that there is a sense of accountability as seen when we see state under Article 12. Article 13 is divided into four parts. The first part, Article 13, Subclause 1, consists of laws inconsistent with or in derogation of the fundamental rights, these laws were formed before the Constitution came into being. Article 13, Subclause 2, speaks about laws which were enacted after the Constitution was enacted. In India, since it is a federal structure and there is separation of powers, the legislature is also divided into three parts, broadly speaking. The first at the central level, second at the state level, and third at the local bodies level. We have the concept of ensuring that there is accountability of the legislation through judicial review. Judicial review is enshrined in Article 13 of the Constitution. We have come across the term void in Article 13, Subclause 1, as well as Subclause 2. What does the term void mean? The term void refers to a particular legislation not having the force of law if it is contrary to this particular provision. Subclause 13(3) specifies what all constitutes law. This would include ordinance, order, bylaw, rule, regulation, notification, custom, or usages having force in the territory of India. Therefore, we see that the ambit of what constitutes law is beyond just the narrow approach of restricting ourselves to law as defined under legislation. Ordinances are passed by the President of India when the Parliament is not in session. Similarly, bylaws are also of importance when it comes to local bodies in particular, and rules, regulations, and notifications. Therefore, it is not just a legislative action, but it is also the executive action that is sought to be made accountable through Article 13, Subclause 3. Article 13, Subclause 4 speaks about ensuring that amendments to the Constitution are also made accountable within judicial review. We see that Article 368 provides for the provision and the procedure for conducting amendments to the Constitution. I shall be discussing the scope of amendments and some important amendments in a subsequent lecture. We have seen through the cases of Shankari Prasad and I.C. Golaknath. Eventually, the Keshavani Bharti case became the landmark case in which we had the concept of the basic structure being established. Shankari Prasad's case saw how Article 13 was exempted when it came to judicial review of amendments. I.C. Golaknath's case ensured that amendments to the Constitution were also subjected to a check and balance. There has been a plethora of cases which specify the scope of judicial review and fundamental rights. One such case was Keshavani Madhavan Menon versus the state of Bombay. This saw the challenge to the Section 18 of the Emergency Press Act, wherein Keshavani Madhavan Menon was being prosecuted for publishing a derogatory article with respect to a newsletter with respect to Mazdoor ke khilaf sajish. It was held by the Constitutional Bench of the Honorable Apex Court in this case that the particular provision of Press Emergency Act was exempted from the challenge as sought by the petitioner under Article 19(1)(a) of the Constitution as well as Article 13, Subclause 1. That it was held that there was no retrospective application of Article 13, Subclause 1 in the present case. This leads us to the first of the two important concepts that have evolved over a period of time by judicial review. The first being Doctrine of Eclipse. There are two cases for this matter. One, Behram Khurshid versus State of Bombay, which saw a successful challenge to Section 66B of the Prohibitions Act, wherein the petitioner was being prosecuted for driving under the influence of alcohol. In this case, the Honorable Supreme Court has held that if at any subsequent point of time the inconsistent provision is amended so as to remove its inconsistency with the fundamental rights, then this amended provision cannot be challenged on the ground that it is violative of the Constitution. The doctrine of eclipse can be interpreted in its very literal sense to mean that when the fundamental rights came into being, the fundamental rights eclipsed the provisions of certain legislations which were contrary to the Constitution. We have another case, which is Bhikaji versus State of Madhya Pradesh, in which it has been held that as per the doctrine of eclipse, certain provisions of legislations which are contrary to the Constitution would cease to be in existence after the fundamental rights came into being. The second concept that we come across is the doctrine of severability. This is a very important concept because the Supreme Court has been cautious of exercising judicial review when it comes to determining the veracity of various legislations. And it has sought to follow a more cautious approach in ensuring that whenever there is a law which is inconsistent with the Constitution, and if it is possible that a particular part of that legislation can be severed or cut such that the rest of the legislation can continue to exist, then at the first instance, judicial review is to be exercised in a cautious manner. And instead of holding the entire provision or legislation contrary to the Constitution, that particular part of the legislation which is contrary to the Constitution can be severed or cut, and the rest of the legislation would continue to have the force of law. Therefore, it has been held that the valid portion, if it is not so closely mixed up with the invalid portion, then the same can be separated, provided it does not change the context and the meaning. While exercising judicial review, as well as while exercising the doctrine of severability or the doctrine of eclipse, one must not lose sight of the doctrine of harmonious construction, which seeks to ensure that laws are interpreted keeping in mind the legislative intent or the objects and reasons for which that particular legislation was enacted in the first step. We see that invariably the parliamentary debates also play a very important role in determining the legislative intent. That is why only certain laws which would not abrogate the meaning or the legislative intent if they were to be partially eliminated and partially retained, only for those laws would doctrine of severability be applicable. While I conclude, I would like to emphasize on how Article 12 and 13 are to be read together while enforcing fundamental rights. Because Article 12 defines state, which means against whom can fundamental rights be enforced. And Article 13 provides justiciability to fundamental rights. We have come across plethora of important judgments where the judiciary has played a very active role in ensuring a broader interpretation of fundamental rights. One such case would be Menka Gandhi versus Union of India, which is a landmark decision when it comes to enforcement of right to life under Article 21. And it is this particular case which saw an expanded version of Article 21 coming into being. And now we have various rights and the way of life has changed with the broad interpretation of Article 21. With this, I conclude my lecture on Article 13 of the Indian Constitution. Thank you.